Hello viewers, welcome back to my channel. So today I will discuss with you the doctrine of res judicata. So the students who are pursuing LLB or BA LLB, this video will be helpful for them or any other person who wants to gain knowledge about the legal matters can see this video. So without any further delay, let's start the video. Before knowing the res judicata, we about to know what is the meaning of res and what is the meaning of judicata. Res means subject matter and judicata means adjudged. Thus, res judicata means a subject matter which has been decided by the competent court. Section 11 of the Code of Civil Procedure deals with res judicata. The doctrine of res judicata basically states that once a matter has been decided by the court of competent jurisdiction, then no party, whether the plaintiff or defendant, can permit it to reopen it in a subsequent litigation. Okay. In a case Satyadhan Ghoshal versus Diorjin Devi, it was held that the doctrine of res judicata basically based on the principle of giving a finality of judgment. What is said that once a subject matter is decided, it shall not be adjudged again. Let's understand it with an illustration. Suppose A sues B for possession of certain property, okay, on the basis of a sale deed. But B impugns the sale deed as fictitious. Court upheld it and dismissed the suit. Later on, A files another suit against B on the other property on the basis of same sale deed. Then the subsequent suit is barred as fictitious because in the former suit the court upheld that the sale deed was fictitious and it was directly and substantially decided by the court in previous suit. So this suit will be barred by doctrine of res judicatum. What is the nature of this doctrine? This doctrine concepts a public interest, that for the interest of public when a suit is brought before the court of law, it must be come to an end whether sooner or later. It also based on the principle of justice, equity and good conscience. Means when a party who has succeeded in the former suit should not be harassed by multiplicity of proceedings involving the same issue, and thereby it prohibits the multiplicity of suits and vexatious suits. Object: what is the purpose of the doctrine of res judicata? Why we need this doctrine in the Code of Civil Procedure? Because the doctrine is based on three legal maxims: nemo debit bis vexari pro una et idem causa, which means no man should be vexed twice or harassed twice for the same cause of action. Suppose a person has defeated in a suit and give compensation to the judgment holder, but the judgment holder again filed that suit on the same subject matter for the compensation. Then he have to pay the compensation again. So to prevent this, the doctrine was incorporated in Code of Civil Procedure. And second, interest republica ut sit finis litium, which means in the interest of state, the litigation should come to an end. If a person, suppose a person files a suit, and if the suit is continues for years after years, then it will not be justificable. Then for speedy trial for avoid multiplicity proceedings, it is decided to incorporate it. Res judicata pro veritate acquipitur. It means a judicial decision must be accepted as correct. If it is not done, then a person can file a number of suit after judgment is given, and a number of judge can interpret the suit in a number of ways. Then there should be a separate several decision. It will not be justificable, and its essential ingredients condition for it: the matter directly and substantially in issue in the substantial suit must be directly and substantially issued in the former suit. Okay, and the former suit must have been done between the same parties. If it is uh, decided by the judge between A and B in former suit, subsequently it should be on the A and B, not B and C. Then the parties are different and the doctrine of res judicata will not be applicable. And if the parties must have been litigating under the same title, means under the same capacity they are litigating the suit, and the court which decided the former suit have the jurisdiction to try it. The court must be competent court. If it has no pecuniary jurisdiction or subject matter jurisdiction, then it will not operate as res judicata. And if the matter directly and substantially in issue in the subsequent suit, the suit must be formally heard and decided by the court. Then the doctrine of res judicata will be applicable. If these 5 conditions are fulfilled, then only the doctrine of res judicata will be applicable. Let's see another judicial decision, which is Mathura Prasad versus Doshi by N.B. Jijibhai. The court held that generally a competent court gives a decision on a point of law, it is operates as res judicata. But if a pure question of which is not related to the facts which gives rise to a right does not operate as res judicata.